Good morning, everyone. Good morning. I get probably the greatest sense of estate planning energy in a room that I've seen in a long, long time, and it's a wonderful thing to hear. Thank you, Mary. And I first met Mary just about a year and a half ago at a conference for one of my business qualifications as an elder planning counselor, and I got to hear Mary, and I went specifically to hear Mary because I thought this project was ideally suited. It kind of lives to the mantra that I try to live by on a day-to-day basis, is that if I can tell this story to one more Canadian family, then we'll all be in a better place than what we have been. So my presentation is about what the will doesn't say. We've heard from a lawyer, we've heard from an accountant, and those are people I work with on a daily, weekly basis. And what I get to is more of the nuances about the other matters in estate planning. So just who am I? Beside a smiling face, the EPC is an elder planning counselor designation that I had started with back in 2003. And it was because most of my clients were moving into that mature population. I am a very young baby boomer and have seen most of the post-Depression era children mature and the baby boomers mature, and I've been following them all of my life, and some with consternation as housing prices have risen, and I've tried to catch up with them. So most of my work has been seeing all of our society and all of my clients mature into other stages of life. And that was important for me to understand the needs and concerns of seniors and also their health and abilities. And one of my key concerns is with my client consultations is how is the mental and physical abilities of my clients? And I check that from year to year to see any significant transitions that need to be reported to either family members or important people. The CEA designation is the Certified Executor Advisor. It's a relatively new designation, and again, it ties in with the needs of most of my clients in the senior markets. It helps me to help my clients when it comes to just what we're talking about today. I'm a financial security advisor with over 30 years of experience. I've been dealing with retirement income, and estate planning for that length of time. And like the ladies before me, a wealth of experience and both positive and negative. I come from a spiritual background, and it helps me as a human being in our society to be able to help my clients and their families at a very difficult, stressful time in life when we're dealing with grief and paperwork. I work from a holistic perspective, and what that means to me is that I take into consideration not just the physical assets or the will, but I take into consideration the family dynamics, people's health and abilities, and try to bring that all together to include as many of the areas possible for people to consider or need to consider when it comes to an estate plan. I'm a lifetime member of Advocates, which is the Financial Services Advisors Association, $1 Million Roundtable member, and as we've said there, planning counselor as well. Estate planning. Most important thing that I do with my clients is to get to know them and their families. Most of my client relationships are not just a one-off, a consultation and we're done. Most of my consultations go over months, years. I have client plans that have been in place for 25 and 30 years where I'm very close to the family. I think that's key for me is to know the family and they to know me. It helps in the full planning process. We certainly do discuss and review the will, financial affairs, and current insurance situations. We create a detailed inventory of the estate, and that was mentioned earlier. I actually go through a document, and I love the idea. Whenever I get a chance to see somebody who's got the banker's box already created, I say a little prayer, because most times it's gathering, compiling that together. I compare that to, in another stage of my business, when we're talking about a young family with children. and we're talking about who they wish to see as their guardian for their children. And if the proper planning is done, it makes it so much easier for that individual to want to take on that role. So for example, not only is it that they're written into the will as the guardian, but they're also named on some life insurance or have some cash reserves to be made available to themselves so they can actually do the job that they've been asked to do. And the same goes for estate planning. So we take that inventory in our initial consultation, and it allows our clients to feel like they've got a sense of where everything is. And I love my seniors, my post-depression era clients, but they tend to be, they save hard. And I don't know if you've seen that in my neighborhood, there's squirrels all over the place. And those squirrels are bearing nuts in every different place they can possibly come up with. And I see it time and time again where there is this diversification of diversification. And God bless them. That's a wonderful thing to consider, but it makes it very difficult for estate planning and also for their own abilities as they mature in life to be able to reason where everything is. So a great deal of my work is the paring down, the simplifying so that it's down to a dull roar with only a few people involved in the discussion, and a few people are the go-tos for the information and the resources. Makes it so much easier. I chiefly facilitate a family discussion meeting, and what that is to me, in the beginning, the middle, and the end, this is about communication and or miscommunication in some of the negative situations. And I see it far too often. I see and hear about what mom said at Christmas time while they were carving up the turkey, and what mom said to someone else at Easter while they were doing the dishes. Gotta tell you, it makes for an interesting family dynamic. And then you add into the consideration of most of us turn back in our family dynamics to back when we were 6, 8, and 10. And that brings in those power struggles and dynamics of the individuals and who's in charge and who said what and how that all plays out. So the family discussion helps us to clear the room and make sure that everyone got on page. And if need be, it's recorded. So they all have an opportunity to know exactly what's been played out here in the presentation. We talk about budgeting, we talk about tax planning, we individualize the estate, try to make it personal for the individual, and we talk about power of attorney services where we can support the people that are in play both as powers of attorney and executors. I am associated with a number of lawyers and tax preparers and professionals in other areas for estate planning to help along with the journey. On the financial planning side, as I mentioned earlier, we talk about retirement and retirement income planning. There's a lot of this is about income streaming and tax efficiency and how things should move along towards the end of life. It's investment and insurance and tax preparation. We talk about creditor protection for assets. We also look at the designations of which institution holds the investments, because there are differences in legislations for both the Bank Act and the Insurance Act for investments. We look to try to bypass probate or estate evaluation if we can, depending on the nature of the investment and the purpose behind it. Okay, here's my legal disclosure. This presentation has been prepared for information purposes, general guidance only, and does not constitute professional advice. You should not act upon this information given to you today without obtaining specific professional advice. Every estate situation is different. I am not a lawyer, I am not an accountant, nor a government official, nor have I ever played one on television. A little humor in the room today. There's Mr. Frosty, it's March. It's time to talk about estate planning. I often get the 11th hour phone call, we need to do something. Just as I often get the call from somebody who's been to a funeral about life insurance. It's fascinating how we bond and connect when it's real. And the other one, which I hear far too often, it says here, we should talk about our final arrangements so the kids aren't burdened with it. And he says, why should we? Why should I care? That won't be my problem. Let them take care of it. And the wife says, right, well, at least we talked about it. And that in many cases is about as far as it goes or gets to. And I applaud you all here this morning for being here. It's a beautiful Saturday morning, and I'm sure there are many other things you'd love to do, places to be, but you're here, and you're here for a very important reason. So just why haven't you prepared a will? And most of you, I think I'm preaching to the choir this morning, but most of you are in that position. Did you know, according to the recent studies, 51% of the adult Canadians don't have a will? And the room goes silent. And even more staggeringly, 71% don't have powers of attorney for care and property. We spend more time planning the last or next vacation than we do on these matters. And the two ladies before me and myself, that's what we spend our working days trying to do and promote. And if we can move those numbers a little more in the correct category, it would be awesome and amazing. I'm going to share a little story with you, and I tend to go off page often, and I also tend to take questions throughout, but Mary's asked me to leave it to the end. I teach I've created and teach a financial literacy course in a high school near me. And if you can imagine grade 12 students who've been through that course sat at a Wednesday morning at 10 o'clock and they created a will. To have 18-year-old kids doing that. And the one story I'm going to share with you is a prime example. It's very simple, but it's a very basic example of some of the work that I can help foster and understanding. This young lady sitting at the table had gone home and done her homework, came back with all the inventory items in her estate. And Mary and I did a podcast on estate planning is for everyone, because it is. As long as you have people you care about and you have any meaningful asset, either of the heart or of the bank account, there's a reason to be able to start this process. So this young lady, she said to me, I have an older sister and a younger brother, and I have a bank account, I have a car, and I have a cat. That's her estate. And she said to me, I think I'm going to leave the cat to my sister and the car to my brother, and they can fight over the bank account. And I asked her, so what's your sister up to? And she said, well, she's heading off to university. And I said, I think maybe giving her the cat's the right idea? She said, no, probably the car makes more sense. I said, yeah? And what about the cat? She said, well, then I guess I'll leave the cat to my brother. And I said, have you ever asked your brother if he likes cats and if that's important to him? And don't you think you might want to leave him the bank account? Because it's not going to be free and easy to look after the cat, is it? And the light bulb went on, and she said, yeah, that makes perfect sense. And I said, the next thing you have to do is you have to go home and talk to them about these things. That's part of the estate planning and family discussion that we talk about. So the head in the sand syndrome. The first bullet is probably the most damaging, which is, I don't want to talk about death. I deal with death. That's a big part of why I'm in where I'm at, because I'm comfortable with what has to happen in the process of death. Not a lot of people are. It's not always easy getting those family members to that table because they don't want to talk about mom not being there when mom is there. But it's important. I mean, none of us are going to make it out of this life alive. We're all going to have to go through. So let's be adult about it, and let's prepare what needs to be done. Yes, we can have emotions because this is an emotional time, but let's have a logical discussion about what's right and what needs to be done. Some of the others are, feel that the estate is simple and I don't need to worry about it. My spouse will get everything, so why do I bother? It costs an awful lot of money for a lawyer, and is it really necessary to do that? And I've done a do-it-yourself will. I can either go online and get one of those kits and boom, you're done, or I even wrote it myself as a holographic will. Those are the excuses that I tend to see. So what happens if you don't? You lose the opportunity to choose who will administer your estate. You lose the opportunity to plan the succession of assets and minimize probate fees and/or income tax. Your estate will have to pay higher taxes. The will is the only place where you are able to designate a guardian for any minor child. A loved one's death is a very stressful time for family members, and most are not prepared for the legal organizational steps needed to close an estate. And there are higher costs and more time consuming in the long run not having it. It's been mentioned already, but one of the first things I find when I get involved in the case is, where's the document? It's as simple as that. Where is it? We moved 3 or 4 times, or it's under a bin somewhere. It would be important to know where the document is. So part of our work is to go digging to find out where it is, or what lawyer was the one involved in creating it, or what office has then succeeded that office to find out where this document might be. Do your powers of attorney and your executors know where the will is? It may sound simple, but I've seen so many cases where they think they are, but we can't even find the document. And do family members know? This has already been discussed as well. Again, some of this is basic information for people who really are dipping their toe in the water for the very first time. This is about powers of attorney. Powers of attorney is the individual who is responsible for your affairs pre-death. An executor is responsible for all of your affairs once death occurs. That means everything from the funeral costs to final wishes, contacting CRA, lawyers, and the list grows. It's interesting when I see a difference between who the power of attorney is and who the executor is. Sometimes they don't easily transition. Sometimes somebody in one role still thinks they have power and authority at a time when it's transitioned into the other person's responsibility. It can be a little difficult getting documents moved from one individual to another. And so it's a very delicate walk. Often I try to recommend that if that person as a power of attorney was capable, would they not be also capable as the executor? This is why it's vital that you have thoroughly discussed your estate plan with your executor for at least, and know where to find where the will is. My clients do a to-do list with me where we put together the information package. So we do an inventory, and that's about a 12-page document, and it lists not just assets, it lists the family tree, it lists the important people and the people of trust, and it lists wishes, right down to if mom wanted this kind of flower at the funeral and this dress, then that's what we're going with. It's all documented. So it makes it really easy. It's very much like the power of attorney document. I'd like to make it as black and white as possible and take the guesswork out of anybody's hands. And if you are a power of attorney for health, that's a difficult challenge. Oftentimes I recommend that the family goes to the doctor to get a full consultation on the do lists and don't lists for the person who's going to receive the care. That's the do not resuscitate orders and the other, down to what feeding arrangements will be acceptable, what housing arrangements will, all those sorts of things, to make it so much easier for the individual coming in as the authority who doesn't have to make decisions. No one wants to make a decision. They want to implement a decision already made. From my experience, that's the best way to proceed. I talk a lot with my senior clients, and it's usually over a cup of tea. And these discussions go days and weeks, and time to reflect talk about who are the right people, who are the important people. And most often it usually is, in the family order, it's usually the eldest child and usually the male. That tends to be the biases we have here in Canada and North America. And that may or may not be the right person. And oftentimes I'm bouncing back the idea and concept, and it's been mentioned earlier. Do they live close by? If they're not in the province, this creates significant challenges. Do they live close by? Because there's going to be a lot of hands-on that's going to be required. And I think of a case of a client family where the executor lives in BC, and she makes trips about every other week home during the initial stages to deal with the estate and the rest of the family. She's the right person, but she's not in the right place. Who do you trust? Because in the end, we're all going to have to trust somebody. And for some of us, it's hard to let go. Some of us, it's very difficult to appoint somebody and know that that's going to be okay. Because in the end, we're not going to be here to make any more resolutions. It's going to be up to those individuals. So you got to trust, you really do. But work hard to determine who is the right person or people to trust. Is it family? I have situations where that's the last choice and not a very good choice. I have situations where clients have adult life insurance policies for their children who will never get to own their policies because they don't trust them. Close friends. I've seen situations where there had to be a quiet conversation with the family because a close friend knew the individual better than anyone else, knew their wishes, knew their day-to-day thinking, all that sort of thing, that the kids had grown distant from mom and not really inside of where mom was at that point in time. Or is it professional? Is it a distant third party or an unrelated third party that would be ideal under difficult family dynamics, if I can put it that way? So, what are your wishes? That's one of the most difficult questions to get an answer to. We are so busy in life building and doing and having and creating. It's hard for people to come up with, what do I want? It really is. It's not an easy task. And some of it is because we don't want to think about it, but some of it is that how do you make sense of this? So there's a lot of work that has to go into what are your final wishes? That sounds like an easy one, but how many people have actually had that conversation with family members about what's supposed to happen? The most common statement I get is, well, you know. Right? Is it burial? Is it cremation? Is there something else? It's really a challenge. And for many who don't have a religious affiliation, it's even getting more and more difficult to have those discussions because there's nothing in that process that is going to fit or seems like it defines who they are. We also are, and this is just a side, we're also doing an awful lot to bypass a process here, which is very dangerous for our own physical and emotional and mental beings, is that we do have to go through a transition. There is a beginning, a middle, and an end. And if we bypass that end and move on to the next, we get caught up in the future. And it's been my experience over my 30 years, if there are people who are denying death or pushing it aside, that it will catch up with you at some point or another. Part of my work is to see that we transition with this, that we do give it its time and space. And so, what are the personal items? And again, that becomes the more difficult. It's pretty easy to go to the lawyer and go, I'm dividing my assets between my living relatives in this percentage. That's pretty easy. But what about the more delicate matters? Who gets Grandpa's painting? And why? The gifts, and what was mentioned earlier is, if you're going to be the executor, things like passwords. I mean, there's a pretty big fiasco going on with Facebook right now. And keys. Where's the keys to the security box? Where's the Where's the access codes? How to remove mom's profile from Match.com. You're laughing. You're laughing. It's there. We are into a digital age where there's a whole lot more to be considered than what's in that banker's box or in the bank account. Coming up. There we are. So why? Why is it important to make your wishes legal? So most of my work leads up to the point when people say to me, and I had this conversation this week with a client, said, I'm thinking of updating my will. Great. Let's have a conversation before you go ahead and do so. Much of my work is done in the preparation to lead to the two ladies that came before me, to go to your lawyer and go to your accountant, and then we work in conjunction from that point on. There are 3 types of wills that are available. I recommend the legal will. I don't like leaving ifs, ands, or buts up to interpretation. But if it's a matter of getting something versus not having something, I'll accept the other 2. I even, something I saw that a holographic will was accepted. It was written in the frost on the front windshield of a car. How to prepare the best plan. Have the family discussion meeting. So I'll consult with my client. We've put all the parameters together. We've inventoried the assets and the important people. We've got through the wish list of what's important and meaningful. We've had a brief dialogue with the family to know that they're all on page and that the powers of attorneys and executors know who they are and have agreed to the roles. And that's another big one, because I see that very often where they didn't know they were on and not so sure they want the job. Oops. And so once we've got that confirmation, everything is made legal that needs to be made legal, and then we come back and we have the family discussion. So everyone that's important in the dynamics here gets to hear the message. Mom's sitting at the table, and if need be, the conversation is recorded, and everyone has a copy of the important information. Having the family discussion, it's my strongest point towards preempting any family dynamic issues. It's pretty hard to dispute what Mom said if Mom was sitting there and we all heard it at 12 o'clock on Thursday, because we were all there for the same message. If I have time, I have 4 cases, and these are all real life people, although the faces are not the real life people. And I'll just run you through these 4 cases and see if there's anything of importance that is meaningful to you. The first case, this is the case of the too busy to solve the problem. I was meeting with a client in Headwaters Hospital in Orangeville, and we were going through an estate conversation with a new executor, and that was a wonderful discussion, eye-opener for the individual, and the family was very appreciative of the consultation. And she mentioned to me that she'd been talking to the family in the next room over, and that she thinks there's a real issue there, and maybe you should go and talk to the daughter about their needs for estate planning. And so she introduced me, and we had a 10-minute conversation. Ian, age 75, he had a massive heart attack, and it was close to whether or not he was going to survive. He did, and is still living and doing well at this point. He was divorced with 2 adult children. He was also a business owner. He had a relationship with a woman that was no longer in place, and she was named as power of attorney and executor. And his daughter, who actually worked in his business and was managing things while he was in the hospital, had no relationship to any of those authorities. So we had to have this conversation. And Ian, bless his heart, typical businessman, he was busy focusing on what he does in his world. I'll get to that another time. And I think a lot that happened in his life, that heart attack was certainly I think was an inevitability to happen in his world. So we had to have 2-hour-long discussions as he was capable to talk about what truly were his wishes today. This was a tough man to get wishes down. It really was. He kind of liked to be vague and recognized there was a problem, but wasn't sure he wanted to solve the problem right away. And it took us a lot of work. It was about 3 or 4 meetings before we got to detailing what his wishes would be. He saw the problems, and then we found solutions to fit the problems that he had. Like, he had to remove the power of attorney that was in place because she didn't want the role, and nor was she connected to the family. We discussed a full estate plan, and by the end of all of our discussions, he was out of hospital and returned back home. We had rearranged things so that it was put into a proper perspective and order. So we'd done what we needed to do from an estate planning perspective. It was all then made very legal, and the family's in a better place today, and he's sleeping well now. So that's Ian. Case number 2 is the case of the regular estate maintenance for life changes. And this is Barb, who's 84. She's a widow with 3 adult children and family. I've been working with Barb and her family for over 20 years and seen Barb through the passing of an adult son and her husband, and the life dynamics that have changed in her world. We've adjusted and modified, managed, and brought down to a dull roar the squirrel mentality that had gone on in her world. We arranged things. She recently sold her home and moved into a retirement home. That asset was put into an insurance investment, so it would bypass the estate, and was naming the children as beneficiary. Also a tool that I use often. And recently we had a discussion about her executors, and she had named her 2 eldest daughters as executors. I should back up first. She, 10 years ago, removed one of her daughters from her estate. That was a year-long process of agony for her because, as any adult would feel, that's a very difficult thing to have to go through. The daughter had excommunicated herself from the family. She took a year to plan that through before she put pen to paper and make that change happen. I am pleased to tell you that 10 years later, the daughter came back into the fold and the will was changed or adjusted. And 3 months ago, she talked with her 2 daughters again, and her second daughter had decided she didn't want to have to be involved. She wasn't in agreement with some of the terms and conditions, so she'd rather step back from it. So the will has been adjusted and changed since then. But that's probably one of the initial family discussion meetings. I can remember that Thursday evening having all 3 of them while they were still communicating with each other at the same table for the same discussion. This is a woman I give great credit to because she had the courage to talk about her death at a time when family really didn't want to have to discuss the matter or issues. So that's Barb. Case number 3 is the case of the family discussion meeting at the right time. It's another family that I'd been dealing with, husband and wife, for many, many years, and putting things in the proper perspective for their plan. But never had we had that opportunity to have the discussion with the 2 daughters, and diametrically opposed children I've not seen before. And it was fascinating to have them at the same table to have this discussion. One came absolutely because she's a planner and this is what she wants to do. The other one wanted nothing to do with death and mom whatsoever, but to get her to actually come to the table was an encouraging factor. She then learned what her role and responsibility would be, which took a great deal of pressure off her shoulders because she assumed there was going to be this mountainous task with paperwork. And when I happened to remind her that she's jointly in this position, that her senior sister, who is the planner, would certainly be taking care of more of the paperwork, she was a little more comfortable that her role was going to be to help support in this process. And this lady, my client here, June, later had a stroke 2 months ago, and so this planning meeting took place in January. She's had a stroke in June, and so the timing was so appropriate to have those discussions. June's doing pretty well right now, but the family's in a better place because they know what their roles and responsibilities are, and know that everything is actually in place today. And finally, case number 4 is the case of trying to do the right thing. I feel badly about this case. I worked with Diane when her husband passed away, and this is a woman that was in great grief and distress, and we took significant time to talk about what needed to be happening at that point in time for her. Like most of us as parents, we want to treat our children equally, as fairly as possible. And so the easiest point is to say, well, I'll just have them all share and they'll all be responsible. And that's where the problem comes into play. 4 children, and I dealt with the death claim when Mom passed away a couple of months ago. I had 4 different phone calls from 4 individuals claiming on the same life insurance policy as executors, and all 4 of them questioning who else had called, what other information had been released, and gave me the information of what lawyer to contact on their behalf. So they had all lawyered up, the walls had been built, and there we are. So nothing has been moved on. They're all suspicious of each other, and all Mom wanted to do was the right thing. And the room goes silent. Okay, so that's the case studies. From there, typically what I do is, as I mentioned earlier, I monitor and review the estate plan every 3 to 5 years. Things can change. As we note, family members come, family members go, wishes change, insights into who you are and what you want to see happen change. So when any of that happens, it's time to make the phone call and have the discussion about how to resolve the matter. Because life is, these documents tend to be hard documents, but life tends to be more organic and changing on a daily, weekly, yearly basis. Change in tax law, change in estate laws, all those sorts of factors come into play. So why do you want to maintain and look after things? It's important. We try to proof as much of our estate planning as possible, but you can't cover off every possibility. There are things that can happen that put things, a wrench in all the works that happen in the situations. So no plan is complete. It can't protect for every eventuality. What we try to do is reduce the risk, know what we know, and work from there with the best possible solution for the situation you face. So no plan, obviously, there'd be increased costs and fees. There'd be tax issues. Could be misdirected funds. There certainly will be time delays in distribution of assets, and more time there's family disputes that happen at that point. As I said in the beginning, part of my work is to see that people are in a better place. I use the Boy Scout philosophy, which is do a good deed and also make the campground better than you found it. And that's what I present to my clients and their families. What we're trying to cover here is an opportunity to make sure that people are in a better place, that the family affairs are left in good order, that you can rest at night and know that things have been looked after. There's not more boxes, not more stress for a senior who doesn't need more stress. And in the end, your family will thank you. If you've done the right things, it makes it so much easier in the process. If you've organized, if you're prepared, you've planned, thought it out thoroughly, had the discussions, the family will have an easier time managing when you're not there. That's a little bit about my services and structures. I think most importantly, I make home visits, I consult with my clients, I'm there and available when crises happen and it is needed.